presentation is part of a series of video trainings on family law put together by the Urban Justice Center's Domestic Violence Project. This training will focus on custody and visitation in New York City. This training is designed to provide general information on custody and visitation. It is not designed to provide legal advice or guidance on any particular case or matter. When in doubt, ask a lawyer. For starters, it is important to understand that there are different types of legal proceedings, and different courts hear different types of cases. In New York City, the family courts hear the following types of cases: custody visitation, support cases, including child support and spousal support, family offense proceedings, abuse and neglect cases, juvenile delinquency cases, and PINS cases, which stands for Persons in Need of Supervision. The next court that I want to discuss is the Supreme Court. Contrary to popular misconception, in New York, the Supreme Court is not the highest court in the state. Instead, it is the court that handles matters of divorce. Please refer to our training on divorce for more information on that. The third court I'm going to mention is the Integrated Domestic Violence Court, or IDV. IDV hears cases where there is both a criminal case and family matrimonial case involved. Note, not all criminal cases involving domestic violence will end up in IDV, but some do. In this training, we're going to focus on custody and visitation matters in family court. For the purposes of this training, we're mainly going to focus on family court filings, although recall from earlier that custody and visitation matters can also be decided by the Supreme Court under certain circumstances. So now that we understand the types of cases and the different courts that can hear them, who are the players? You may already be familiar with the players in a criminal case from TV and movies. In a criminal case, the government brings a case against a defendant after a crime has been committed. For example, the People versus O.J. Simpson. In family court, the players are a little different. The parties to the case are called the petitioner and the respondent. The petitioner is the person who starts the court proceeding by filing the petition, and the respondent is the person who the proceeding is against. For example, Ryan and Taylor have 2 children together. Taylor files a petition in family court for full custody of these children. Here, Taylor is the petitioner because Taylor filed the petition, and Ryan is the respondent because Ryan has the chance to respond to Taylor's petition. Then we have the referee and judges. Family court matters are determined by a judge or a referee. Even though they are called different things, the role of a referee and judge are essentially the same when it comes to custody and visitation. These are the people who issue orders and make determinations based on the facts presented. The main difference between a referee and a judge is that when appearing before a referee, the parties will be asked to consent to the referee's authority to hear and determine the case. Once consent is obtained, referee orders function in the same way as judge-made orders. If the parties do not consent to the referee's authority to issue orders, the protocol varies from borough to borough. Some courts will send the case to a judge to be heard, while others will allow the referee to continue to hear the case, but will ask the referee to take notes to send to a judge who then gets to make the final decision. An 18B is a court-appointed attorney. You've heard it on every cop show. You have the right to an attorney. If you cannot afford one, one will be provided for you free of charge. Although those Miranda rights are talking specifically about criminal constitutional rights, the same principle applies to custody visitation matters and orders of protection in family court. You have the right to an attorney. If the court determines that you cannot afford one, they may assign you one for free. And these attorneys are called 18Bs. Some judges will require proof of income to make this determination. It is good practice to bring along pay stubs, tax returns, proof of public benefits, or a letter from an employer when asking for an 18B to make the process go smoother. Next we have attorneys for the children, or AFCs. If children are involved in a family court proceeding, the court may assign an attorney to represent the children's interest in court. In custody visitation matters involving children over the age of 3 or 4, most judges will appoint an AFC to represent the children. Depending on the circumstances, some judges will appoint an AFC for children under the age of 3, if they feel that it will be helpful. In some boroughs, courts assign AFCs from the Children's Law Center, which is an organization that specializes in child advocacy. In other boroughs, AFCs are assigned from a pool of available 18B attorneys. It is important for parties to keep in mind that an AFC's job is to represent the children, not the adults. Attorney-client privilege exists between an AFC and their child clients, but those rules of privilege do not apply to, for example, an AFC's communication with the parents of their child clients. As such, an AFC will be allowed to speak privately with the subject children away from their parents. It should be noted that depending on the age and developmental abilities of the children in question, an AFC is allowed to substitute judgment. This means that an AFC is allowed to provide their own opinion on what is best for the children. But if they do this, they must tell the court that it is their opinion and not the opinion of the child. Generally speaking, though, the older a child is, the less likely an AFC is to exercise their right to substitute judgment. And finally, we have ACS or CPS, the Administration for Children's Services, aka Child Protective Services. These are the investigators who look into allegations of abuse and neglect of minors. There are a few safety-related things you should be aware of before filing a petition. For starters, it's not always safe to file in court. Although you may want to immediately go to court and have a judge hear your case, it may not be the best choice for you. When you file something as the petitioner, the respondent must be notified. Remember, it's in their name. They are the respondent because they have the right to respond to what was filed, and they can't do that if they don't know it was filed. You should also know that the respondent can file a petition in response. For example, if Wyatt files a petition against Avery for custody, Avery can file a cross-petition for custody in response. Avery could also file another type of petition, such as an order of protection or a child support petition. You should also think about address confidentiality. If you do decide to file a petition, you can request to keep your address confidential from the other party on court papers. You do this by filing an address confidentiality affidavit. But remember, this is a request. It is not a guarantee. And 5, you should also think about safety planning around court appearances. The respondent doesn't just have the right to be notified of a proceeding and to respond to it. The respondent has the right to respond in person, so you should be prepared to see the other party in court. Okay, before we go any further, I want to address some common myths and misunderstandings about custody and visitation. Myth number 1. Moms always win. False. Although in the past mothers were perceived to be the natural caregivers of children, today the courts understand that both mothers and fathers play important roles in caring for their children. As such, there is no presumption in favor of mothers winning custody over fathers. Myth number 2. If I'm a survivor of domestic violence, my abuser doesn't get to see the kids. False. The courts are reluctant to bar a parent from seeing their children, even in situations where one parent abused the other. Myth number 3. If I flee from an abusive relationship without my children, I can file in court later and still have an easy time winning custody. False. This is a misconception that can hurt a party's custody case. Courts are reluctant to uproot children from their current residence, especially if they are doing well. In instances of domestic violence, leaving a child in the home with an alleged abuser can undermine any claims that the fleeing parent believes that the children are unsafe with their abuser. Myth number 4. All judges are sympathetic to survivors of domestic violence. False. Unfortunately, not all judges are sympathetic to survivors of domestic violence, and even for those who are, domestic violence is only one factor out of many for the courts to consider, and it must be proven at trial. And 5. Court won't take longer than a few months. False. Contrary to what TV and movies might suggest about the timeline of a legal case, custody cases can drag on for years, with long adjournments between court dates, sometimes as long as 2 to 3 months. And even after a final order has been reached, modification petitions can still be filed until the child turns 18. We'll talk about that situation later. Okay, so now that we've cleared that up, let's discuss what a custody visitation case actually does look like. For starters, what is custody? In New York, custody is divided into 2 different parts. There's physical custody and there's legal custody. Physical custody is about where the child physically lives the majority of the time, and legal custody is about who gets to make important decisions for the child, such as the child's medical decisions, their health decisions, education, extracurricular activities, and religious upbringing. These important decisions do not include day-to-day decisions like what the child is going to eat that day or what the child is going to wear. Day-to-day decisions are made by the parent who has the child at that time. So we know that custody has 2 parts, but each part can take different forms. Custody can be sole or joint. For example, you can have sole physical custody granted to one parent or a joint physical custody arrangement. Sole physical custody is where the subject child or children live with one parent the majority of the time. The parent that has sole custody is called the custodial parent, while the other parent is called the non-custodial parent. Joint physical custody is where each parent has the child or children for 50% of the time. Please note that joint physical custody is primarily for parents who are able to get along very well and who ideally live a short distance from each other. However, the decision is ultimately up to the court. Even in cases of domestic violence, a judge could order the parties to have joint physical custody. In the same way that you can have sole or joint physical custody, you can have sole or joint legal custody. Sole legal custody is where one parent has the authority to make important decisions for the child or children, whereas joint legal custody is where both parents have an equal amount of decision-making authority and are expected to make major decisions for their children together. Even in the situation where one parent has sole legal custody, however, they often must still consult and inform the other parent about major decisions involving the child or children. This is because an award of sole physical or legal custody to one parent does not mean that the other parent's parental rights to the child are terminated. A non-custodial parent is still a parent. Custody is not the same as parental rights. When it comes to legal custody, there are additional forms that it can take. Joint legal custody with final decision-making authority to one parent or a third party. Joint legal custody with final decision-making authority requires parents to work together to make major decisions about their child's well-being and upbringing. But in the event that the parents cannot agree, the court gives one parent the final say. For example, if Stevie and Alice have a child together, and the court orders joint legal custody with final decision-making authority to Alice, Stevie and Alice are expected to make decisions about their children together. But if for whatever reason they can't agree or come to a compromise, Alice gets the final say. Sometimes the courts will give one parent final decision-making authority over one type of issue, and the other parent final decision-making for a different issue. This kind of an arrangement is called spheres. For example, let's say Alice gets the final say when it comes to medical decisions for the child, but Stevie gets final say when it comes to educational decisions. Alice's sphere is medical decisions, and Stevie's sphere is educational decisions. And finally, the court can issue an order of joint legal custody with final decision-making authority to a third party. This arrangement says that if the parties cannot reach an agreement about a major decision for their child, they must defer to the guidance of a third party, such as the child's teacher or doctor. the parties could also agree to go to a mediator to help with the decision-making process. These kinds of orders can name a specific third party who gets to make the decision, or generally state that the third party must be consulted. Okay, so who can file for custody, which is otherwise known as standing? In New York City, the legal parents of a child can file for custody or visitation rights. This includes biological and adoptive parents. For mothers, the court automatically recognizes their parental rights over the children that they give birth to. For fathers, however, there are 3 ways to establish paternity under New York law. Number 1, the marital presumption. When people are married and have a child, the court automatically presumes that the husband is the father of the child born into that marriage. Number 2, an acknowledgement of paternity, or AOP. If the parents of the child were not married at the time of the child's birth, the court will recognize someone as the legal father if the father signs an acknowledgement of paternity. An acknowledgement of paternity is a form that New York City hospitals give to unmarried birth mothers when a baby is born. If the form is completed in the hospital at the time of birth, the father's name will appear on the baby's birth certificate. And finally, number 3, an order of filiation. If a child is born to unwed parents and no acknowledgement of paternity is signed, the law treats the mother as the sole legal parent of the child in question until told otherwise. To establish parental rights and responsibilities without marriage or an AOP, either or both parents can file for an order of filiation to have the court establish paternity. This can be done with a DNA test or by looking at the manner in which the proposed father has behaved towards the child. For example, has this individual acted like the father of the child? Standing by a non-biological and non-adoptive parent may be established by clear and convincing evidence that there was a preconception agreement that proves that the parties agreed to conceive and raise the child together as co-parents. Consider this example. Quinn and Jamie are in a relationship and decide to have a child and raise it together. 5 years after the child is born, Quinn and Jamie break up. Even though the child is only biologically Quinn's, Jamie could still petition the court for parental rights because the parties agreed to have the child together before the child was conceived. Throughout this training, we will mostly focus on parent petitioners, but it should be noted that other relatives can also file for custody, but this is only if they can show extraordinary circumstances, and although not impossible, it is rare. So, where do you file for custody, or which courts decide issues of custody? In New York City, 2 courts have the authority to hear and determine issues of custody and visitation matters: the Supreme Court and the Family Court. The Supreme Court can issue custody orders when the parties are married and in the process of obtaining a divorce. Family Court decides all other custodial matters that occur outside of the context of a divorce. You can file for custody or visitation in the borough where either party lives or the borough where the subject child lives. For example, Kenley and Parker have a child together, but Kenley lives in Manhattan and Parker and the child live in Staten Island. If Kenley wants to file for custody or visitation, the petition can be filed in Manhattan or Staten Island family courts, but not any of the other 3 boroughs. There may be some strategic safety reasons why a person might choose to file in one borough over another. For example, if Kenley is living in a domestic violence shelter in Manhattan and Parker doesn't know this, Kenley may choose to file in Staten Island to avoid giving away their location. Earlier, when we talked about sole physical custody, we learned that in situations where a child lives primarily with one parent, that parent is called the custodial parent, and the other parent, the non-custodial parent, has a right to visitation, also known as parenting time. Visitation can be unsupervised or supervised. However, it is important to note that even in situations where the court orders supervised visits, These types of visits are not meant to last forever. The goal of the court is to reach a place where both child and parent are capable of spending unsupervised time together. Courts structure visitation schedules on a case-by-case basis by considering the best interests of the child or children in question. Absent extraordinary circumstances, New York presumes that it is in a child's best interest to spend at least some time with their non-custodial parent. Extraordinary circumstances requires proof that it would be detrimental to a child to spend any time with their parent. This is an extremely high standard, and it is not common for the court to make a finding like this, even in instances of domestic violence. There are different types of parenting time that a court can order, or that parties can agree to. From most restrictive to least restrictive, they are as follows: supervised visits by an agency, supervised visits by an agreed-upon party, therapeutic visits, sandwich visits, day visits, and overnight visits. Let's go through each of these one by one. The most restrictive type of visitation is supervised visits by an agency. These are visits that are overseen by a professional who specializes in supervising and observing parent-child interactions. Visits that are agency supervised will usually occur for 1 to 2 hours once a week, after which the agency supervisor is expected to provide a report to the court on how the visit went. Either or both parents may be required to pay for the supervised visits. If the court determines that the parties cannot pay, the court will pay for a limited number of supervised sessions, usually capped at 10 hours of supervision. The other type of supervised visits are visits which are supervised by an agreed-upon party. This third party can be a grandparent, mutual friend of the parent, or, if it's safe, it can sometimes be the custodial parent themselves. In these situations, written reports about the visits are generally not required. Note: if supervised visits go well, which they normally do because the non-custodial parent is usually on their best behavior when being watched, the court will seek to move to a less restrictive form of visitation. The next type of visitation is therapeutic visitation. These are visits where a therapist or psychotherapist will engage either one or both of the parents and the child, either separately or together, to understand and resolve the issues between the parties. In these cases, therapeutic visits will either play the role of the supervised visits themselves, which is more restrictive, or they can be in conjunction with a normal visitation schedule, which is less restrictive. If the court orders these visits, a report will generally be provided to the court. Next, we have sandwich visits. This is a visitation arrangement where the supervisor is present at the start and end of the visits. In the middle, the non-custodial parent can take the child away for unsupervised time together. The supervisor's role here is to check in at the beginning and end of the visit to make sure that the child is okay and that there are no issues. Depending on the need, a written report debriefing sandwich visits may be required by the court. Unsupervised day visits. Day visits, as the name suggests, are visits that occur during the day. This means that the child visits with their non-custodial parent during the day, but then returns to the custodial parent before bedtime. The amount of time for the day visits vary from case to case. And finally, we have our least restrictive form of visitation: unsupervised overnight visits. Overnight visits are visits which, again, as their name suggests, the child spends the night with their non-custodial parent. This will often include weekends, school breaks, and vacation time. Note: even if the court begins with a more restrictive type of visitation, be prepared for the visitation to change and become less restrictive as the case progresses. Here are some additional things to note about parenting time. For starters, courts will generally want to begin visits as soon as a custody case begins, and they will do this by issuing a temporary order of visitation. This is important to remember, because by opening the door to custody considerations, you are also opening the door to almost immediate orders of visitation for the other party. The next thing to think about is the manner in which exchanges will take place. In order for visitation to occur, the court or the parents have to think about how to transfer the child from one parent to another. This is called the exchange. If the visits are being supervised by an agency, the agency should provide a means for a safe exchange. The court can also order that exchanges take place at a police precinct or a neutral public location, such as a 24-hour fast food restaurant or a library. This type of arrangement is common if there is a history of domestic violence. As a practice note, when picking a public place to do exchanges, make sure that the location's hours work with the visitation schedule. You also want to think about exchange locations that will work regardless of the weather. For example, you wouldn't want to choose a public park. Some people prefer to pick a restaurant or store as their exchange location because it allows them to purchase something and get a time-stamped receipt as proof that they arrived to the location on time. If the parties feel comfortable enough, exchanges can take place curbside at a parent's home. If the parties would like to limit their interaction, the court can schedule exchanges to take place at a child's school. For example, the non-custodial parent may pick the child up from school on Friday afternoon and return the child to school on Monday morning. And finally, even when visits are unsupervised, courts can still set in place some rules and guidelines regarding parenting time. For example, the court can allow unsupervised visits on the condition that certain people not be around the child, or that visits take place in a public place. If the child is in school, the court can order that the non-custodial parent make sure that the child does their homework while with them, or that they attend certain extracurricular activities. The court can also instruct parties not to speak poorly about the other party while the child is with them. Okay, so we've talked a lot about the different types of custody and visitation arrangements and what each form entails. But how does the court determine which set of arrangements is appropriate for a specific case? The cornerstone of custody and visitation matters in New York is the Best Interest of the Child standard, BIC for short. Under the BIC standard, virtually every question or issue that arises during a custody visitation case boils down to the single question of what is in the child's best interests. Note, in cases where there are multiple children at issue, what is in the best interest of one child may not be in the best interest for another. As such, the BIC standard considers a multitude of factors on a case-by-case basis to determine what custody visitation arrangement best serves the needs of the child or children in question, and how much weight to give to each factor. Some of the most common factors considered are which parent is the primary caretaker, the quality of each parent's home environment. For example, do they each have a place for the child to sleep, or do they live with a roommate? Each parent's ability to provide for the child's emotional and intellectual development, the financial status of each parent and their ability to provide for the child in that regard, the existence of siblings. The court recognizes the importance of sibling bonds and values a custody and visitation arrangement that allows a child to maintain and foster a sibling relationship. The court also considers a child's preference. The court will take into consideration their feelings when structuring a custody and visitation order. The older a child is, the more weight the court is likely to give to their preference. Maintaining stability and a sense of security for the subject children is another important factor for the court. The ability to co-parent, and which party is more likely to encourage the child to have a relationship with the other party. This is called considering the friendlier parent. The court doesn't want to give custody to a parent who will try to cut the other parent out of the picture. And finally, the court must consider a history of domestic violence when determining custody and visitation. This list of factors is non-exhaustive And depending on the judge or referee overseeing the case, different factors will be weighed differently on a case-by-case basis. The best interest standard is based on the belief that in most cases, children are better off with both of their parents in their lives. It should also be noted that having a disability does not automatically bar someone from being a custodial parent. In fact, the court cannot discriminate against a party because of their disability, physical or otherwise. That being said, the court may still consider the impact that a party's disability may have on their ability to care for a child, and any steps taken by the party to mitigate any detrimental impact of their disability. For example, if Murphy is depressed and struggles with an anxiety disorder, the court will consider whether Murphy goes to counseling sessions and takes prescribed medication to address these difficulties. Let's talk a little about the petition itself and the filing process. In order to start a custody or visitation case, you must file a petition with the court. This petition should state the facts of the case by first explaining the relationship between the petitioner and the respondent, and their relationship to the subject child or children. The most important thing that the petition needs to do is explain the reasons why the petitioner is asking for custody or visitation, and why it would be in the child's best interest for the court to grant their request. In order to do this, you should try to be as specific as possible in your petition. This means including any incidents of domestic violence that may have happened, as well as any indicators that the petitioner is the person best suited to care for the subject children. For example, if Kenley and Sean have 2 children together, and Sean files for full custody of these children, Sean's petition might include the following points. Sean has been the primary caretaker for the children since birth. Kenley does not have beds for the children to sleep in. And Sean has an order of protection against Kenley for instances of domestic violence. You want to summarize the details of any supporting incidents for the court. Be specific about what happened and when it happened. If you can't remember the exact date, it is okay to approximate a time frame. Service. Remember we learned earlier that the respondent must be notified of the custody or visitation petition and be given the opportunity to respond. Service is the way the respondent becomes notified. Once you've drafted and filed the petition, the court will set a court date to give the petitioner time to serve the respondent. New York State requires personal service, which means that a person may only be properly served by someone who is not a party to the case, so not the petitioner or respondent, and over the age of 18. The papers delivered must include the summons to appear, which tells the respondent when to come to court, and a copy of the petition itself, which tells the respondent what the petitioner says happened and the reasons why the petitioner believes their proposed custody or visitation arrangement is best. Service cannot occur on a Sunday, and for custody and visitation petitions, service should occur at least 8 days before the return of process date. The person who serves the respondent should fill out a document called an Affidavit of Service. This document should be signed by the person who served the respondent in front of a notary. This document tells the court things like when and where the respondent got the papers, and confirms that the respondent was in fact the person who received them. If specifically requested, the police or sheriff can attempt service. If they do perform service, they will provide the Affidavit of Service directly to the court. However, for custody and visitation petitions, there may be a fee to have the police or sheriff perform service. The first official court date after filing is the return of process date. First, I'll talk about what happens when service is completed. I'll address issues related to service on the next slide. This is the date when the petitioner proves that the respondent was properly served by giving the court the original Affidavit of Service. If service was done, then expect both parties to appear. Both parties may ask for an attorney during this court date. The court will assign a free attorney to individuals who cannot afford representation. The court will also assign an attorney for the child, if needed. If the court determines that a party does not qualify for a free attorney, then the party will decide if they want time to hire a lawyer or represent themselves. If the party wants time to find a lawyer, the judge or referee should set a new court date to give that party time to find representation. If the party waives their right to an attorney, the court can proceed. The court may issue a temporary order of visitation on the first date. The court may also order a court-ordered investigation. Generally, the court will adjourn to another date. If the respondent does not appear, but the petitioner can show proof that the respondent was properly served, the court will usually set another court date and mail a notice to the respondent. This notice will let the respondent know that if they fail to appear again, the case will proceed without them. However, the court doesn't have to do this. The court could also just decide to proceed with the case without the defendant on that day, without attempting to notify them a second time, although this is not common. So, what if there are problems with service? Sometimes there are problems with service, for example, if the respondent is served on a Sunday. Or there can be a problem with the Affidavit of Service itself, for example, if it was not signed by a notary. If the problem is with the service itself, the court can either order the service be done again, or, if the respondent is present, they can waive the defect in service, meaning that they acknowledge that there was a problem with service, but they're not going to make an issue out of it. If the problem is with the Affidavit of Service, the petitioner can ask for time to amend or fix the Affidavit of Service to show that the respondent was properly served previously. If there are problems with service, the petitioner can ask for another opportunity to attempt service. If the other party appears, the petitioner can ask to serve the respondent on the record in court. However, it is up to the respondent whether or not to agree. If the respondent agrees, the case can proceed that day. If the respondent does not agree, the court will require the petitioner to have the respondent served outside of court. Even if there are issues with service, the petitioner must still show up to the return of process date. If the petitioner does not appear, the case will be dismissed. Once all of the parties have been served, the case can begin. Parties should understand that they will be under a microscope during the entire proceeding, and that their interactions with the subject children, as well as the opposing party, will be scrutinized as the court works to determine what is in the best interest of the subject children. The court may request a court-ordered investigation of both parents. During a COI, investigators may speak with a child's teacher or therapist, as well as any other person who lives with and interacts with the child on a regular basis. Depending on the investigator, COIs can be more or less detailed. When there are allegations of mental illness on the part of one or both of the parents, the court can also order a mental health examination of those parties. This means that the court can require one or both of the parents to be interviewed for 1 to 3 hours by a mental health professional who works within the court. These examinations are designed to assess a parent's mental fitness and may require the parent in question to bring proof of a medical diagnosis and any medication or treatment they are undergoing to address these needs. After the interview, the examiner will provide a report to the court. And finally, the court can order a forensic examination. Like the mental health examinations, a forensic examination is conducted by a medical professional. However, unlike a mental health examination, a forensic exam is extremely detailed and usually conducted through a series of interviews over a period of months. The forensic examiner will be expected to testify at trial, as well as provide a very detailed report to the court. These professional examiners often make recommendations about the case itself, and their insights can be helpful to the court when ascertaining the needs of the subject children. It should also be noted that it is not uncommon for parties to keep a close eye on each other. For example, the other party may show the court emails or text messages that the parties exchanged, or screenshots from social media posts. Parents should be aware of this and mindful of what they say and how they say it, even when they think no one is watching. As already briefly mentioned earlier, between court dates, the court can issue temporary orders of custody and visitation. But at the end of this long process, there are a number of ways a custody visitation proceeding can be resolved. The first is on consent. This means that the parties come together and reach an agreement to settle the case. The second is withdrawal. At any time, the petitioner may ask to withdraw their petition without prejudice. meaning that if the petitioner withdraws, they can file again in the future if they feel they need to. Although, if the petitioner does withdraw their case, any temporary orders issued during the pendency of the case will no longer be in effect. The third way is a resolution on default after inquest. If at any time the respondent fails to appear in court after being properly served, the judge may proceed with an inquest. An inquest is a one-sided trial where the petitioner answers questions under oath about what happened. Based on the testimony, the judge will decide whether or not to issue the order. If they do, they'll decide the terms of that order. The final way a custody visitation case may be resolved is by trial. If a custody visitation case goes to trial, the petitioner must establish beyond a preponderance of the evidence that it is in the child's best interest that the court issued the order the petitioner is asking for. And they may do this by offering witnesses, testimony, or evidence. The respondent will also have the opportunity to rebut the petitioner's case by offering their own evidence. After a trial, the judge or referee will decide the issues of custody and visitation and what the terms will be. In some cases, a judge may want to hear directly from the child about what they want. If this is the case, the judge will conduct an in-camera interview with the child. This means that the judge or referee speaks with the child and their AFC away from the child's parents. The court will not tell the parties what the child said during the in-camera interview, and this gives the child an opportunity to voice their desires to the court without feeling pressured by their parents' presence. Okay, so now we've walked through the process of a custody and visitation case in New York City from start to finish. I hope that this video tutorial has been helpful and informative. As a reminder, the information provided here is general and is not intended to be a substitute for legal advice on any particular case or matter. As always, when in doubt, ask a lawyer. Thanks for watching.